Now, there was some information that I had. Actually, I was browsing into the Upwork platform, and this was a list of some of the projects that I thought that you might want to use as access to the opportunities with these keywords. Like if you type research reports, if you type market research, business plan comparison, so all of these that you're looking at might be something of value for, especially for you, Anthony, to see what is involved in these kind of researchers. Okay. And
Okay.
then perhaps you can create some samples of your own, just so that you can back up your proposals with
Okay.
having a knowledge of these type of researchers or whatever is involved within these areas. All right. So
Okay.
just a pointer for you to actually try it out.
Okay.
Um,
Thank you.
yeah. So if you want, I could just copy and paste these in your
Yeah, I'm
chat
going to take
box.
a picture with my phone if that's okay.
No, no, it's fine, but
Yeah.
still put it in the chat for the benefit of everybody.
Okay.
Here.
Thank you.
So, and of course, with the Upwork, don't worry too much about the cost or the pricing. I guess one of the things important in this kind of business is references. And your profile needs some sort of endorsements, some good reviews. So, for compromising a little bit on the cost, perhaps you might want to just take up some of the projects just to get that feedback, a nice one, you know.
Okay.
Anyway, we got to get started with this internet law. Now, I think I'd like to wrap it up in the next class, which will be on Wednesday, and would make your weekend a long weekend in the sense that you wouldn't be have to take a class on Friday. So that's my attempt. Besides, I'm also going to give you a recording which is going to cover anything that gets missed out because of the time shortage. Those recordings are from the previous batch, and that is pretty much going to conclude everything within the internet law. Important part was the where you needed the coaching. Really, the coaching was the um, sample exams or the sample tests, Q&As. So my expectation would be that if you didn't get the chance over the weekend to go through it, at least attempt it before the next class. And it's not to say that I'm not available to discuss anything to do with the exams even after the next class on Wednesday. I'd still be in touch through the email, and if the need be, we can do the Zoom call. So, my whole idea of giving this class and to make it a success is for you to be able to pass your CIRS exams. So, on account of that sort of responsibility, I would say that I'll make myself available if the need be. But let's start with law. I'm going to skip a few slides, which is more on the introductory side. And I'm going to start with the one that is going to talk about legal jurisdiction on the internet. And by the way, there is always a question about whether certain laws are going to be similar for the Canadian version versus the US version. And bottom line, like in what capacity or in what type of coverage do we have for the two different regions, two different countries? So to answer that, you can think of both the countries as having similarities in the legal structure of or the regulatory framework of the law that pertains to so what we are going to discuss. There will be multiple elements of law that we'll discuss, but there will be similarities. And we deliberately did not include things which would be exclusive. But in generality, we collected the information that uh, works for the research work or which is necessary for doing online research, plus something that generally would require to be covered um, within the scope of the common law, which is, the common law is a little bit different from the law that is the written law or that has got, the, okay, um, I don't want to get myself dragged in that direction, but let's say common law is with examples or case laws or whatever, the similarities are in case laws. A lot of times cases are quoted between the two countries as having the same impact or similar impact. So the past case laws from Canada are also discussed in US, and the US laws are also referred and discussed in Canadian legal system. So that might be a surprise to you, but this is how close it is in terms of what is commonly considered as family law or uh, you know or the law by example or the case law. And it is for that reason that we have included some of the case laws, which is actually not more than six that we'll be discussing. Six of them would cover pretty much everything that we'll be discussing. For instance, I'm going to start with the jurisdiction and the concepts of jurisdiction. Without going into types of jurisdiction, let's look at the conceptual side of what is considered in common law as a commonality. Courts authority, first of all, if you are dealing with internet, you are in a virtual world. You are not dealing face to face with individuals for signing something or for dictating something or for any kind of infringement that would be considered direct infringement with interaction, with a physical interaction. Because it is in the virtual world, there are a lot of moving parts in the virtual world. You can have a business that is in one country, which is registered there, and you can have your server sittings in another country or another region, and where the server is serving the pages or server is delivering the software as in SaaS, which is, subscription type of softwares. Then you've got the gateway connections to the transactions that go through the merchant accounts or the bank accounts or accounts like Visa, PayPal, and so on. Those are called payment gateways. Gateways can be different. Gateways can have certain legal aspects that they cover between those who own the website and the consumer that visits and pays through the credit card. Whereas for those that are actually using their credit cards, they have a relationship or a banking agreement between the card service they subscribe to uh, and also covered under the consumer protection laws, depending on the jurisdiction. Okay. So jurisdiction can have meaning for consumers that might be different from what it would ideally be if something is happening on the ground within the jurisdiction of where you are doing the activity versus the activity that is actually the deliverables, which is coming from the other side or from the vendor's side. There could be a liability and obligation towards the consumer, which is again dependent on the region, the type of product, and also the international laws, which to a certain extent give safeguard for and for the transaction to happen between the consumer rights of one country as having a treaty within another country that is delivering the content or delivering the products. So there are a lot of moving parts. That's all I'm saying. without confusing you further, let's just look at the basis of what is considered to be a jurisdiction, or where you are going to go and file any kind of claim in the court of law. What type of rights or what type of jurisdiction does the court have over someone that is virtually transacting with the consumer or the claimant or the plaintiff? You understand where the plaintiff, the words like plaintiff and the defendant. Plaintiff is someone who's filing something, filing a claim, filing a case, and the defendant is someone who is now supposed to respond to the plaintiff's plea for what you call the grievance, or you could say for the liability that they're held liable for. So the defendant is supposed to defend the claims that comes against them. But in between, there is a legal system or a judge or a jury or a place where you actually file the claim. So, what is it that we are discussing now? We are discussing the authority of a jury, um, the court itself, the judge for having the right to receive or allow to receive the claim from the plaintiff. That is the jurisdiction of the court, and this is of two types. Here, the court's jurisdiction is based on subject matter. It's called subject matter jurisdiction. The other one is called personal jurisdiction. Excuse me. So, the difference is, in the subject matter jurisdiction, the court would receive application in the courts that would include, let's say, bankruptcy related, family law related, which is divorce and things like that, child custody, or it is related with any criminal act. So the subject matter jurisdiction of the court is one thing. On the other hand, the jurisdiction to receive applications, taking an example of bankruptcy court, for instance, debt recoverable, someone plaintiff file in a court of law, which could be, let's say, any court. It could be a lower court or it could be superior court, irrespective, whichever court it is. That court may have a jurisdiction to receive that application based on the nature of the claim, which in this case we took an example of banking, or the bankruptcy. Now, that is the jurisdiction which we call subject matter jurisdiction. The second jurisdiction is called personal jurisdiction, meaning that the individual who has filed the claim against the plaintiff uh, is claiming that the plaintiff is not a resident of that location or may not be connected directly to that jurisdiction or to that region. Yet, the court may be able to send out a subpoena or send out something that would make the defendant to be present in the location of where the plaintiff has filed the claim. So that kind of jurisdiction is called personal jurisdiction. For an individual who is a defendant, they may not actually be in that region, may be a non-resident, or maybe an individual that is not even the citizen or maybe living outside of that country. But because of the nature of the claim or nature of the crime or nature of the event that has happened, it gives extraordinary powers or extraordinary jurisdiction to ask for that individual to be present and defend themselves in this particular location where the plaintiff has filed the case. So that makes it a personal jurisdiction of the court. Now, we are not going to go in and look for what kind of laws or what kind of breaches of law are subject to personal jurisdiction. All right. because that is a matter that would take a long time. It's not part of our course. The idea here is for you to actually be able to distinguish the two major type of jurisdictions. No worries, Joanne. Thank you for coming anyways. Uh, we appreciate it. Thanks. We are talking about jurisdictions here, and we just started, so you haven't missed much. Two type of jurisdiction we talked about, subject matter and personal jurisdiction. Now we are going to go forward to look at what is considered to be borderless. Now there is a borderless jurisdiction situation, which means that it is more on the personal side. It is actually best translated as a personal jurisdiction when we talk about borderless jurisdiction. It means wherever the individual might be that is being that is a defendant and someone against whose the case is filed will have to report to or be and allow for the court and for the court to have the right to call that individual in the capacity of its personal jurisdiction. We are calling it borderless, but I explained to you it is same as a personal jurisdiction. Okay. Now, how do you determine in generality the personal jurisdiction of the court? And that is based on something we call it's a test, kind of a test for the judge to determine if they can actually go beyond just their local jurisdiction to go after that individual based on a states. And here we are using the word states, we are not using the word province. So mind you that this is more coming from the USA legal system. States long arm statute. Statute is a law. State's long arm means that state has the ability and authority as well as the power to look or to call or to allow for the plaintiff to file the case in their local jurisdiction. I keep using the word local. When I say local, it can be state, it can be a county. In USA, there is county, there is state, and there is lower courts also, which is I don't know how to name them, but there are these different levels of the court. But long arm statute, when it is considered in the with reference to the state's long arm, it means one state can um, go beyond their um, jurisdiction. Now, in order to determine the long arm statute, there need to be a test. It is called the minimum contact test. Minimum contact will depend on two things. One is the nature of the incident or the nature of the breach of law. And the second is the association of that individual with reference to having some connection inside of that state. And that connection can be, a spouse or an ex-wife living there, frequent visits to the state, a branch office there, some small business there that individual is running in that county or in that state. Um, and as far as the type of breach or the type of law that is broken, it could even be a drive-by, something which could be criminal. You know what I'm talking about? Then there could be hit and run. There could be, something that is of criminal nature, which has caused a grievance or has a cause for the plaintiff to file in that jurisdiction. So these two things or these two elements will determine the minimum contact with that state. And based on the availability of evidence or the nature of the breach, the judge may be able to use its state's long arm statutes or extraordinary powers to gain the personal jurisdiction over the defendant. Yeah. Now, this should be clear. Second is personal jurisdiction and website classification. Now, personal jurisdiction, when we are talking about a virtual world where the websites are interacting or you are interacting with the website and you have a cause to file a claim for whatever reason it may be service that got that was incomplete or was not delivered, fake websites, something that misled you into believing into something that caused a material harm. It could even be only slander and libel, which is, something that is ruining someone's reputation. Even that could be an object or one of the ways in which you can actually think of it as virtual harm. And so there are many. And of course, e-commerce is another kind where the product is not delivered. Anyway, let's look at the liability levels or the levels which would be which would give rise to um, not only a legal claim, but a claim for punitive damages as well as the real damages. And the volume of the damage or the value of the damage that you can claim will depend on the type of website that you interacted with. So everything starts with your communications or your interaction with the type of website, and the judge is going to look at the involvement or the nature of the site that would impact the liability levels. For instance, if it is a commercial, and we call it jurisdiction on sliding scale. On sliding scale, this is just something which would determine the the impact that would cause the level of liabilities that you can claim. Um, and like I said, it could be punitive damages or it could be physical, actually, value of what the, or anything that can be translated into the physical value or the dollar value. So if it is a commercial website, the liability of a vendor or where the user would file a claim would get the highest level of attention from the court, as well as more favorable outcome of the claim that you would file if it is a commercial website. And then there is passive websites. So passive websites means that they are static, just the HTML pages. It is not interactive. You're not giving away any information, so no breach of privacy, no uh, not much of a damage expected just because it is a read. It is just the writing which is exposing some information or from which you may not claim a large amount of damage. So that would be called passive websites. Then there are active websites. Active website means that even when you are registering um, your name or giving any information on the website, which cannot be considered commercial, but at the same time, it is not interactive enough that would lead you to communicate with the third party, or it is a closed box. Yet it is active website, which means only one-sided information is being collected, or you are only acting within the terms and conditions of use of that website. That is called active website. Active means that it has a slightly a higher level of liability from the vendor side compared to passive websites. And therefore, on the sliding scale, I would put it starting from the least amount of damage you can claim, that's going to come from passive website, which is number one. Number two is active website. There's a slightly higher weightage given to the level of damages you can claim. And then there are interactive website, which I would rate as number three, considering that it may give cause for damages that you can claim as a plaintiff, just because it is interactive enough that you Social media, for example, is an interactive website, which means that you are interacting not only with that platform, which is what you are using in order for you to connect with third party or outsiders. So that third party is also one of those that you can actually consider as interactive, and the others who are connecting with you as a result of you using that social media site. I keep using the word social media, but I'm talking about interactive website, and social media is one of the examples. So you are connecting with those who own the platform, and you're connecting with outsiders that interact with you. So interactive website has a certain level of checks that prevents the platform owner or the vendor of those social media to protect themselves for privacies, from breach of trust, and other things with the moderators and all that. So it is a kind of a system of social media, which is using its resources and its rules of use and things of that nature to prevent someone suing them, or giving choices for the user who are interacting. But when you are interacting with third parties, which is where you are basically using it as a connectivity platform or a networking platform, the level of harm increases. Um, and therefore, you will see a lot of disclaimers also on those sites. Anyway, interactive website is number three in line for the level of damages that you can claim, and the most that you can claim or you can sue for or against those who are delivering goods and services using commercial websites like e-commerce websites, their level of damages can be claimed to the extent or the highest extent, and the legal system would support it only because those are commercial websites. So you can even claim incidental damages or punitive damages or grievance damages, goodwill damages, anything you name can be uh, can be considered uh, to the full extent of the law to give it a more favor for the user. User is kind of lost in the e-commerce websites, and like I told you, there's a lot of moving parts. There are so many contact contracts in play while you're buying. Even if you buy something of a value for like $5 or $10, the whole process is covered by the contracts, by the kind of obligations and liabilities that each of those characters or those players within that within that choreographed, I would say, choreographed process of doing the transactions by physically paying, by actually paying through your credit card and getting a physical delivery. In between, there are so many contracts. I don't want to get into the detail, but I briefly told you there is a contract which is between the bank and the vendor that is using the gateway. For example, PayPal may have a contract with abc.com for using their gateway in a certain way. Then you got, the merchant services of the user whose credit card is applied. Then you've got delivery of goods, and within that, you are basically coming up with or agreeing to what we call click wrap contracts, which means that unless you click on something or you check the box and you read terms and conditions, you won't be able to go to the next level. So that becomes a kind of a contract which is more like a compliance that you've agreed to, sometimes knowingly and a lot of times unknowingly. So there are a lot of moving parts, and therefore, for the reasons I told you, commercial website has the highest level of liability on the jurisdiction sliding scale. Okay. So moving to the next one slide, I would think that it is best that We take a break of 10 minutes, and then I will talk about intellectual properties. After the jurisdiction part, we'll talk about the intellectual properties that we as researchers have to be very careful about using data, using information, reuse of information, building on top of information, difference between trademarks and copyright. Sometimes we mix it. At times, the client is not very happy because, you have reused or applied information which may be copyrighted. So anyway, let's get to this. Give it 10 minutes, 15 minutes, and then I'll continue. So see you shortly. Okay, everyone, I'm back. Let's continue. I'm going to talk about intellectual property, and there are three types of intellectual properties. Intellectual property means that you have the ownership and exclusivity to use branding and file for patents. We are looking at these three different types of intellectual properties. Copyrights is primarily original expression of something that you have created, something that could be a writing, could be very personal things that you have created, um, artistic work. Software is actually controlled through the copyright laws and not the trademark. It could be a question in the exam. There could be films, songs, paintings, photographs, and things of that nature. So those are all copyrights. Trademarks, on the other hand, are two types. Trademarks are used exclusively for branding reasons, for recognition by the users or the common people who would have a perception translated through designs or through some wordings that at times you used to think it is copyrights, but it is originally considered trademarks. For example, um, I think Nike has a slogan, which is actually recognized by consumer as having exclusivity for Nike only. Um, and those are word marks. So trademarks can be word marks, and trademarks can also be design marks like logos. On the other hand, patents will be something that has an element of innovation in it, something that is exclusively created as a knowledge or some information or some process or some design that is not comparable or has a distinction that would not look like or would be having a duplicate or um, its competitor. So that makes it very exclusive, and the way the patents are accepted takes a long period of time, meaning that there is a huge database of patents, and sometimes you need a specialized, a professional or someone who can be a lawyer and a professional in figuring out if the patents are, first of all, acceptable or not, or you can file it or not. And the second thing is that the technology or the person who is technical enough to know that the design difference is one of the innovations or one of the new or added technology that is part of that patentable design or that patentable process that needs to be determined by the experts. So patent is an area which a researcher generally don't get involved in or would not have a problem figuring out the difference between what is patent and what is trademark and copyrights. But for the research purposes, we are going to look at copyrights and trademarks as a knowledge area which is essential for research purposes. So, what is a copyright, or what are the rights that are given through the copyrights as a filed or as someone that is considered original work? Um, the rights include the right to reproduce the work. So, if you have the copyrights, you can reproduce the work, you can create derivative works out of it, you can have the right to distribute, you can have public display right, and the public performance right. These statement looks harmless and very much easy to understand just by the way it's written or how it is phrased. But there are so many layers under this. Like, for instance, the right to reproduce the work. In what sense reproduction of the same work is possible? It can even be possible through, um, a public license, or it could be a restrictive license, or it could be a license that is exclusive for educational purposes, and so on. So that would be, the subcategories of reproduction of the work. But for us, we will be satisfied to only understand the main headings to get a general idea. And in order for you to claim a copyright infringement by anyone, you will have to identify the type of infringement for the copyrights. One of the types is called direct infringement, the other one is contributory infringement, and the third one is vicarious liability or the vicarious infringement. So these three types of infringement. And the again, I bring you back to the sliding scale of what level of liabilities you can claim, or to what extent you can hold liable anyone who is the infringee in this case. Okay. So direct infringement is most common when somebody is actually directly copying somebody's work and making it others believe that it is their own. Like, there is no attributes given, there is no reference given, there is just outright infringement. Especially in the softwares, someone has bought a license for themselves to use it, but they have actually uh, done a distribution or given it to somebody else who is not the actual owner, or under whose name the software is not issued. So that is a direct infringement. Movies that are copied directly or distributed illegally are direct infringement. And the onus of defense for someone who is the infringer, no, infringer, infringer, that's the right word, who's the infringer, will be paying highest amount of damages if it is proven to be a direct infringement. Now, contributory infringement means, let me just get back to the book, because book has some information that I don't want to miss out. Um, I'm going to make it appear as a single page, make it more visible. So let me do that. Um, One question I have to ask, if any one of you know how to, how does the copyrights become tied up to your own ownership as the owner of the copyright on on anything that you are about to bring to the public knowledge, or when you are when you are exposing it to the public, how would you protect your copyrights for something that is your original work? What are the different measures you would take to do that? First of all,
Well,
know that copyrights do not require for you to file anything anywhere. The moment you create it, the moment you write something, the moment you have designed something, that becomes your intellectual property, as long as it is the original work, which means it's not copied from somebody else. So that becomes, you become the owner immediately when you do that. Now, who would know that it is you who has created this, unless you sort of make it, or make it a knowledge for others to understand that it is coming originally from, or you are the creator of it? How would they know? Just putting your name under that writing will take example of a writing or an article, something that you are publishing on the internet.
Maybe self-citation. It's like you cite your own work to begin with. That's good practice. While putting the date, it's like someone delivering a course. He puts his own name or the name of the company and the date. And sometimes we see others, put in the sign C for copyright. I don't know whether it changes really something, but yeah, these are
Well,
the
these are
three.
some of the things we do as a protection. But it is something that anybody else can simulate, or they can actually put their name under that writing also. And they can upload anything. Internet has that ability to not do the vetting or not do the checking and let anybody just put their name under anyone's article and say that it, or claim that it is theirs. So this is a problem. This is a serious issue. And if you look at it from the other side, where the researcher is collecting information and giving the right attributes and doing the citation references and stuff like that, it's still not guarantee that the original source is the owner of that or not. So there are these kind of things which really does not safeguard the copyrights as strongly as they should ideally. So one of the things that I would do is to look at where the publication is coming from. Is it coming from a university that has already checked everything and it is already an authenticated information, and that individual who is taking the ownership, or where it is mentioned is the original document that's coming from, let's say, the university itself?
Well, I have a book here. I used to know it by heart, but there's a way to verify credible sources. Like when I used to do research papers when I was in school,
Yes.
we couldn't we had guidelines where we could get the information from. So there's
Mhm.
ways to figure out. There's a standard, at least on a college level, writing a research paper, and I guess it's true for everything else, to vet it to make sure it's a credible source.
Right.
Yeah.
So, I mean, one thing that we can do is we can track it or trace it back to the origin of where that information is collected from with a certain confidence level we have uh, for that source itself. If it is a research paper coming from educational institution, we have some certain assumptions, and we know that it is vetted, it is actually been scrutinized, and so we have that level of assurance. But Joanne is saying that there could be a file name that is connected to the data of origin. Now, the thing is that this type of data is transferable, transportable, uploadable, editable, depending on how you have designed your intellectual property checks. But generally speaking, um, few things I would do that I can suggest might work better. First of all, as far as the breach or the infringement is concerned, there are 10 different ways people can do it. There are 10 different ways people try to protect it also, by uploading, as Joanne is mentioning, by giving it a file name, uploading it as an original document, which would have a time and date stamp somehow embedded in the code or the source code itself. Um, Not sure about how the libraries work, but as far as indexing system in search engines, they wouldn't care less unless somebody would claim it to be their their intellectual property, or if there is a copyright infringement, they can file a claim um, in Google with evidence to show that they are the owner of it. And there are so many things that they can do to emphasize that it is their original work. Thank God that we do have sites like archives.org, or we call it Wayback Machines, or there are other websites that are totally neutral, independent, and their only job is to um, take the pictures and capture the codes of some pages, or the content of those pages that is actually um, recorded on their servers as having it or being the first copy that is uploaded, so that the time and date stamp of the upload is actually collected along with the code itself and the content that now becomes a record in third parties web servers. So that is one of the things that you can do. Second is that there are organizations and there are data banks that would ask you to send them a soft copy of your copyrighted work, so that they can put it in a vault and they lock it, or they can put it in a virtual vault, which means that you don't have to send any physical copy of it. They would just, you can just transmit it, and they would give you a code or a number, just like you would put something in a vault somewhere, where you only know how to open it and use it later in case there is a litigation, or where you have not been able to, let's say, deposit that work somewhere, or if it is not captured anywhere else, then you have to actually, at the time of uploading, and I'm talking strictly about digital files, you will have to capture the code itself and collect it as an evidence of your upload. Um, just to get, and this is a little bit off the track slightly, because now I'm going to mention about how those reporters or journalists, how do they protect their work, especially when they're reporting to the big agencies or they're on the payroll of big agencies, and information being premium, um, especially if it is collected firsthand, and it is not the second or the third copy, or it is not a distributed copy. If it is the original work that is handed over to, let's take an example of Washington Post. So journalist is going to give the work to Washington Post to publish it, and when they publish that, they're going to embed a code that would not reveal exactly some of the details, like date and time stamp will not be revealed, let's say, in the article that is published, or if it is a story that is a developing story on the ground, and it is updated and uploaded uh, with the time difference for the events that are taking place from one time to the next. That type of data is also embedded in the code, and it is considered as a standard practice, or as a kind of an information which becomes a record of sorts for anyone to actually open up the source code and look into the code for this type of info as an evidence. So those are the some of the things that are happening, and that has become a good practice, or a practice of some of the bigger agencies that maintain the integrity of that information as attributable to to that individual who actually holds the rights. Now, as far as protecting the copyright work, generally speaking, you need at all times to copy if it is uploaded. You have to collect the source code and keep it as a record. It's very hard to duplicate that code, or for anybody who's copying it may not be able to use the same code or the same HTML script which is running on the in the background of that content page. So if you can copy that, open the source code and copy it and keep it, it will work as an evidence. Let's move forward. Now I'm going to talk about direct infringement. These are highlighted. So I want you to look at the highlighted part. Direct copyright infringement happens when the author's exclusive rights, such as the right to reproduce, prepare derivative based on it, distribute copies on it, etc., are violated. So obviously, anything that is violated as a consequence of direct infringement of somebody's work outright, piracy of something is direct infringement. Not difficult to understand, but more important is the contributory infringement. Now, contributory infringement, whenever you look at contributory infringement, it has less of consequences of damages occurring for the defendant when you compare contributory with the direct infringement. Direct infringement has the highest level of liability that you can claim. Then contributory is number two, and vicarious is the third set, which means that it has the least amount of liability for the infringer, or, who has actually a limited knowledge of whether something is infringed or not. So let's look at the levels of infringement by differentiating between contributory and vicarious. In contributory infringement, knowledge of the infringement act as well as a material contribution to it are two important factors. So if contributory infringement, that means material contribution. In other words, it could be something that you have taken commercial advantage from, or for which it is impacting or has an impact on the original owner's ability to make money or to get benefit, which may not be exactly money, but a reputation is involved. That could be a cause for a contributory infringement. Contributory also means that you had the knowledge, you as an infringer had the knowledge that you are infringing somebody's work, but it is coming to you through another party, or it is coming to you disguised as original. So, but important factor is you had that knowledge that it is disguised as original, which it is not. So that is a contributory, having that knowledge that it is an infringed, it is not coming from the original owner of that copyrighted work. Then comes the vicarious liability. In this case, let's read it first. The defendant may be liable for the actions of the primary infringer simply because the defendant has the right as well as the ability to control the infringer's act and receives a direct financial benefit from the infringement. Now, if you read it carefully, you will see that they're referring the term primary infringer. Now, primary infringer is someone who has done the direct infringement, but because anyone who is using that work had had least knowledge that it is being infringed, or it is whether that person who is the primary infringer uh, is is the owner or not, they did not bother to verify that, or they thought that considering that it has just come to them as changing hands without having the responsibility to verify if the source itself is the original owner, that would give rise to the vicarious liability. And sometimes vicarious liability has different modes, or you could say that it has different uh, levels of exchange of hands. sometimes the vicarious liability can be something for which the contributor or someone who is now I'm not going to call this person the infringer at this point, but let's suppose it is someone who is handed over the work, but that person did not bother or did not think that they had the responsibility to verify if the original source is the owner of it or not, would give rise to vicarious liability. Sometimes another type is that there are more than a few parties involved that blurs or that dilutes the if the ability for whoever is the beneficiary of that or the last party that is using that work for commercial reasons or not, but using that work um, without having any knowledge because they don't have means to trace it back to the origin. Even so the main liability is considered vicarious from the use of that actual infringed copyrighted work for from which the user of it has gained benefit, but without knowledge. But it does not absolve that individual who is beneficiary of this work or infringed work is is liable to the extent where they are supposed to have at least some knowledge of where the origin is or where it is coming from. So if they have taken the benefit of it without going back and tracking to the original source, it will become a vicarious liability. Contributory versus vicarious means contributory has got a higher level of responsibility, and therefore more damages can be claimed. In vicarious liability, the level of damages can be reduced, or the least damages can be claimed if it is determined that the beneficiary of the infringed work has has a vicarious liability. Examples of copyright work. Piracy is direct infringement. Okay, so we don't need to worry too much about the piracy. Everybody knows what piracy is. It's a intentional misuse or breach of intellectual properties through any means that would result in benefit that can be determined in terms of money, or it can be a benefit that may not have uh, that may not have a price tag on it. Okay. So I'm going to look at what we would consider to be something um, something that will come in the exam as a case law. So let's do one case law or two case laws if we can. I'm going to read or ask you to read this three paragraphs here, and then we'll proceed to get an answer to the questions based on the case study. So if it is visible to you right now on my screen as well as yours, can you read this just to get an idea of what is going on? And then we'll
Yes.
start to answer these questions.
Yes, I can read it.
Excuse me. Okay, so I trust you have read these three paras. If you have, then let's get an answer for the first question. And anyone can volunteer to give their input. Any one of you. So here,
I read.
the first
I,
one, I'll have to, let me do it
you
like
said
this.
anyone can give an answer.
Any one of you can give me an answer if you can volunteer. Say
Yes,
for the first one.
the first one I would choose all of the above. Well, wait a minute.
What
Wait
is
a
the
minute.
copyright infringement issue in this scenario?
Number one.
Photocopying protected without author's permission, professor claiming. Yeah. So I think I agree with what Anthony is saying. Number one could be the correct answer. So let me highlight this. For the second one, which right of the copyright owner is violated in this scenario?
Okay.
All of the above? I think so.
Yes. That's the one I'm yeah, you're right. I agree.
Then I have who is responsible for direct copyright infringement. This would be more important. I think 3 and 4, these two questions are more important. So who is responsible for direct copyright infringement?
The copy shop owner.
Correct. Because it is not the notion that somebody is instructing anyone to do an act which is an irresponsible act for because it's an infringement of somebody's intellectual property. But what is important is to hold responsible someone who has actually acted on it and produced or reproduced something without the author's consent. In this case, the copy shop owner is responsible, not even the student, is because the infringement has to prove that someone acted on it or did the direct or direct copyright infringement. So in this case, the direct infringement is the copy shop owner. Who is responsible for contributory infringement? So if we look at the definition again, knowledge of the infringing act as well as material contribution to it are two important factors in contributory liability.
Yeah, I don't want to be the only one
Material
answering.
contribution. Material, who is the contributor, material contributor? Is it the student or the professor?
I don't want to be the only one to answer.
Don't worry
Somebody
about
else.
it. Somebody else. Majdi, what do you think? Or Joanne, professor? I think
The material contribution is the professor, I believe, because he's the one who's giving the book. And
when
the
they
knowledge,
say knowledge of the infringing act
is the
as well
student.
as material contribution, could it be the professor or it could be the student who had full knowledge of it? Maybe
Student.
the professor did not have full knowledge of it, but in where it is saying that the student realized that the store owner is completely unaware of the risk of this task, try to explain to him the danger of copying another's work without permission. So who knew if it is being infringed? Or maybe the professor had the notion that because it is used for educational purposes, and therefore, you know, everybody's entitled to having copies made for them for the use of, for educational reasons only. Maybe that's the notion that the professor has.
As we say, the end doesn't justify the means.
Yeah.
Yeah.
You know, that doesn't have to be a true statement that the professor okayed it. That the shop owner might have just said that. We don't have any proof that the professor actually knows about it, right?
Yeah. Mm.
Correct.
That's what.
So,
Yeah.
So this is debatable, and what Johan thinks is that the professor should have full knowledge of the rights and obligations of using somebody's work or intellectual property for educational reasons. So in Canada, for instance, the professor can use a portion of it, or maybe few pages can be, but not the whole book needs to be photocopied. It's a common knowledge, I think, and professors should be aware of it before directing someone to do an illegal act. And then ignorance of law is not an excuse. So there is this debate of, and it becomes more difficult to answer. But to my best knowledge and agreeing with Joanne, I would say the university professor is responsible for contributory infringement. The student is only taking directions, even with the knowledge. I mean, the student can be held for vicarious liability, um, but the contributory liability could be that of the university professor. That is my best judgment according to what little I could read in these three paras. So that's one of the risks that you have to take to get the right answer. And I can only give my best answer here and perhaps agree with what Joanne is saying. I agree with that. What is this?
I know this is a little off the subject.
Yes.
There's another type of copyright
Mhm.
that I was going to ask you. Are you familiar with it? But I got to look it up first. Anyway, basically, you know how you go to a website and they make an offer to download an ebook or whatever. And some of those ebooks, you can reuse them.
Yes.
As long as it's a certain type of copyright. I'm sure you're probably familiar with it. I just can't think of it.
Yeah, those books are in public domain and they have a restriction which falls under Creative Commons. That is, some of the public copyrights organizations that regulate or identify or at least define the restrictive copyrights um, under their license, which is considered to be trackable and traceable
Right.
within the
Yeah.
context of that public use law. And then there are clauses within the Creative Commons that define what is fair use of something, you know.
Yeah.
So the idea behind all of those that are freely available ebooks specifically is to share that knowledge or to make use of that within certain parameters of its use. Like you won't be able to resell it, so cannot have a commercial use, or it would
Right.
emphasize the fair use includes only using it for educational purposes, or fair use could also mean that you cannot build anything on top of it, or you cannot use its content to add to your work, or it may require for you to give attributes or to give a mention or give a citation or reference to that by acknowledging the author. And so there
Right.
could be all these caveats within those type of public licenses, right?
Right. I know
Um,
that's going beyond the test. I was just wondering if you.
no, no, that's fine. And then, we talk about fair use. In your opinion, can this be qualified as fair use? Of course not. This
No,
is
no.
direct infringement. You're copying the entire book. And the idea is to distribute it without the knowledge of. So this is obviously a no.
Right.
Okay. Now, next thing I want to talk about, let's see if I'm on the right track, first of all. By the way, you could see the different types of licenses that are, available as public license, like Creative Commons.
Yeah.
You could see
That's
that,
that's
there are these restrictions here. GPL and LGPL, these are licenses mostly for use of softwares that you can reuse, like open source softwares.
right. Yeah. Yeah. That's what it was. That's what I was talking about. That list right there. That's what I was mentioning. Um,
And under Creative Commons, which is recognized as a body that regulates, as I mentioned to you, the public license. It has these logos or these symbols which indicate what type of restrictions are
yeah.
applied.
So the one I was referring to is the yellow, where it
Mhm.
says you can redistribute, copy, publish, display, communicate. I think the only thing you have to do is give the credit to the original. Well, a lot of these booklets that I've been talking about, they already advertise the company's the business that was originally responsible for the ebook or whatever. But they give you
Mhm.
permission to copy it, display it, etc.
Exactly. You can redistribute, copy, publish, display, communicate, etc. But it would not give you a right to sell it.
Right.
That's the only thing. And this is just a small, I guess, a diagram. And of course, if you go through the read and see in detail what it contains, you will get a more clarity on it. This is just showing you at a glance what is considered. See, commercial use. See, with these logos, you can redistribute it. You can even sell it. This is where the commercial use is coming. And you can see that commercial use includes, these, these symbols. So if it has commercial use, then you can actually sell it, or you can, use it as something that can be worked upon or worked on. You can extract anything from it. But what it would not allow you is shown right here. Modify and adopt.
Yeah, but the first column, the yellow, the copy and publish, that's the most common one that I've seen. I have to admit, I haven't seen some of these other ones, especially the commercial.
They're not that common. They're not common. And I don't know. I mean, there are different reasons for somebody to allow its commercial use. Sometimes, they just want it for popularity. Sometimes it is for, spreading some sort of rumors. Sometimes it is misinformation. Sometimes it is advertisement or advertorial of sorts. So there could be so many different reasons for it.
Yeah,
I
yeah,
mean,
like
I
the
would look at it. Yeah, I would be very careful. You know,
well,
any.
the most common one that I've seen, like a lot of these tech companies, as you know, the technology is advancing so fast that the
Yes.
only way that they can sell their product is they give a free class that
Mm.
includes a test with a certification. And a lot
Mm.
of their formats, the
So it's for
material.
their advertisement
Yeah,
and for,
right, right,
maybe their branding,
right,
you know, and some different
right.
motivation. Let's look at trademarks. Trademarks, factors that determine trademark infringement. I've had situations where we had obtained a data or some research papers we have used, some of the statements that we um, actually placed in the title part that turned out to be trademarks or trademark protected. And it had a repercussion for our clients. So there could be a misunderstanding in differentiating between trademarks and copyrights. That's number one. And also in misunderstanding that the word marks or certain slogans or certain search phrases or certain, not search phrases, but certain phrases that you use that becomes visibly available for the public can have a trademark right that belongs to somebody, and that somebody can actually turn around and sue you for it, because they might claim dilution or tarnishing of their goodwill. You know, I don't know what the slogan is for Nike. There was slogan, I can't remember. Play it hard or something like that. I don't know if you remember, but anyways, that was just, you know, a common statement that anybody could use. But turns out it is trademark. So let's look at what are the factors that we have to look for in trademark infringement. The similarity in the overall impression created by the two marks. So, of course, they're talking about design marks. Overall impression means in the eyes of consumers, how the consumers have associated that design to belong to something, and it has to be a product or services. But whatever it might be, if it has similarities, of course, that is number one cause of filing for trademark infringement. But first of all, how do you own a trademark? How would you say that as a business or someone who is, um, who wants to do a branding for their products or services, how would they have protected or kept that or made that mark or whatever you call it, a design mark or a word mark? How would
Well,
they ensure that it becomes a trademark and they have the ownership of it?
well, I guess this is true for Canada, but in the United States, you have to file for a copyright or a trademark rights to that. You have to
Correct.
submit the paperwork, pay a fee. It's a lot of steps.
So the situation is that trademark needs to be filed through the trademark offices, which may have different names, or in US there could be intellectual property uh, department, which is usually regulated under the provincial or I guess state or under the federal government. I don't know, but in Canada, it is protected under the federal laws or what we call the Federal Intellectual Property Act is responsible for protecting the trademarks in Canada. So there are these bodies, and those are different for different countries, but nevertheless, they are responsible for accepting and for filing the trademarks. And therefore, they have offices as well, and they have a system and a process. Now, when we talk about filing trademarks within your countries, you are actually not just dealing with the country itself, but you're dealing with countries that actually work together under the international organization which maintains a centralized database of trademarks. And therefore,
WIPO.
anything that is filed in US or in Canada or Germany or anywhere else in Europe, it lands into a central database, which is also called WIPO database. I'll show you what it is. This is a WIPO database.
Yeah, we
So
have
you
something
can put,
similar to that.
yeah. So this is international. This is where, data is collected from all different countries. You could see that this is filed from Japan. Mm, there's 64 pages of Nike. So this is
Wow.
all, this is a design mark. Okay. In Korea, let me go to a page which is not Chinese. Korean Republic. Anyway, there would be others. How can I go to, let's go to the last page. Korean, Japan. Take another one. Japan is dominating here, no? Anyway, you can search by brand, by logo. What is important for you to understand is that what you're looking at here, for instance, this is called a design mark. Okay. Even if these are emphasize word with um, what 5 alphabets, DELTA, the font itself is considered a design. The height of it, the width of it, all the dimensions of it has to be recorded. So this will become a design mark. On the other hand, there is an example of word mark that I want your attention. Biolex delta, Biolex delta, Biolex. People do funny things here, with the word marks. Let me also. Why is it Japanese and Chinese coming? I don't understand. What is the other brand? So this is a trademark that is filed in France. Okay. And it is filed, owner is in France. It is filed in Brazil. And Giacomo di Giacomo, this is a word mark. because there is no design in front of it. So this is something that nobody else is able to use.
I'm sorry, I missed
Yeah.
what you were saying. What type of database is this?
WIPO, WIPO database. This is international database.
So what you're showing us is if you wanted a trademark, you actually have to file it in all the different countries.
Yes, you can, but it depends. See, whoever is the member of WIPO, you would be able to claim wherever you have filed it, who are, part of that consortium or the countries that have under treaty within the WIPO, they would have um, the capacity and the ability to allow for those filed trademarks to be recognized as contestable within those countries, and therefore there is a common collaboration, and this is the reason why international organizations are put together, so that if you file it in Canada, for instance, and Brazil is part of the consortium of WIPO, the filing of someone infringing it in Brazil would be can be sued, um, even if I filed it in Canada. If my origin is Canadian intellectual property office, where it is filed, I can sue somebody or go after somebody in Brazil, because it is based on international treaties and international cooperation. So that's the reason why WIPO database is valuable. And a lot of times China wants to stay away from it, and there are certain countries that opt out of it. Some of the Eastern European countries deliberately opt out of it. So it's again a matter of who is the member of WIPO. Some of the ways in which intellectual property in trademark is accepted is by classification of some of the products and services that fall under a criteria of the type of services and product. So if the two, let me just open up Notepad quickly, just so that I can show you one example of how these things happen when you actually get into the court of law. Um, what is it that is going to be checked by the judge in the initial stages of determining the trademark um, liability? Number one is similarity of design, of course, that is there. But the second is similarity of what we call nice classification. Nice classification is a system that can be considered as a selection of the criteria that allocates a number to a certain type of products and services. So let's suppose ABC company has a brand that is called Giacomo brand, okay? But the Giacomo brand is selling, let's say, under nice classification 42 and 45, something that makes it different from XYZ company that has the same Giacomo as a brand name, but it is classified under a nice classification of product and services as 77 and 89, randomly, just giving. Now, what happens is that anybody suing for this Giacomo from ABC company against the use of it by XYZ company may not have a strong enough case, because the classification of these products is different. For instance, 40 to 45 can be um, books, and journals that they're selling. And under the nice classification 77, 89, they can be selling shoes and garments, etc. Okay. So because now the nice classifications are different, even if it is the same logo, I mean, logo design mark is very strict, first of all. So let's just assume that it is a word mark, which is use of JACOMO as a word, not necessarily to be described as having a design such as, a type of font, size of font, color of font. None of that is applicable. Let's suppose it is a word mark, which is commonly serves the purpose of having a broader impact or a broader um, claim that would work not only in logos but in domain names and in such kind of things. So people, when they're doing design marks, they also file at the same time the word marks. So in this case, what I'm describing as ABC and XYZ, I'm telling you that Giacomo might be a word mark, and it might be the same wordings, Giacomo, just as words in any fonts. But just because the nice classification is different, ABC company would not be able to sue XYZ as they would want or would win the case um, of trademark, only because the products are different. The other test is in the eyes of consumer, like what is the level of confusion? If the consumer finds both marks to have the similarity that is not able to distinguish the product and services alone, but just the fact that ABC company is more popular than XYZ company, and somebody thinking that the XYZ company is now selling books and journals also, sorry, is also selling shoes and garments, and they would buy shoes and garments thinking that it is the same company that sells books and journals. And just because books and journals company or Giacomo ABC company is more famous and has a higher awareness in the eyes of consumer as a brand leader, they would have a level of assurance or a level of quality assurance, and therefore they might think that they have started selling shoes and garments now. And that would be another reason why someone can contest the trademark on account of dilution of their goodwill or tarnishing of their goodwill. So there could be this criteria as well. So in the eyes of consumers, there is a level of confusion. So if ABC company can prove in the court that there is confusion in the eyes of consumers, XYZ company can be held liable. Another question about trademark that comes to mind is supposing somebody who's been in business for, say, 20 years ago, or started business 20 years ago, and today they look at their brand as having a good footing in the eyes of consumers as a quality goods, but they have not filed for the trademark. Yet there could be another company that started the business maybe 2 years ago and they have filed or registered a trademark similar to the other company that's been there for 20 years. What would be the implication of protection or protecting the goodwill of someone who is not filed for it, yet there is enough big enough consumer market that recognize the 20 years old brand as having a value against the one that has newly come in and filed or registered the trademark. So there is this part that is considered by under the trademark laws as having the rights or certain level of rights that are attributed or given or considered as the as the property of the company that has successfully been marketing something for the past 20 years, and for which consumer has built a recognition, and for which there has been consistent sales and revenue generated. So this part will outweigh the part where a new company who just recently registered, whose trademark is not does not have um, you know the level of recognition as the company which is not filed the trademark but has been around for 20 years. So that can be some of the factors that would actually um, give more benefits to those companies who not registered trademark but have a wider audience and a wider following, and value of the goodwill and value to the brand itself that's been there for 20 years. So all those factors come into play, and therefore trademark law and copyright law sometimes is very expensive to contest, first of all, and to defend also is very expensive. And a lot of times you can think of it as having a lot of technicalities and onus of proof that needs a lot of information collected for the plaintiff to pursue this or to win the case. And a lot of times you also have to look at the size of the defendant to know whether or not you can actually benefit by claiming the damages, or the damages can be affordable for those who by the defendant. But and at the same time it can cause a damage which can be much wider and much larger to the original owner of the trademark, even if it is against a small size company. So there is a lot of technicalities that one has to go through in order for someone to win the case, and at the same time to have a rationale to see what could be the level of damage that is caused to the goodwill or the saleability, or even for the future viability of the product to be maintaining its consistency of goodwill and reputation. So all that is a very long debatable subject on intellectual properties, particularly in the trademark situations. So anyway, I think that should conclude our today's lecture. I'm sure you must have learned a lot of things today, especially in trademark. I think I've spent a lot more time than I'm supposed to. Let's then let
I've
me.
got,
Yeah, go
I've
got a
got,
question. Go ahead. Go ahead.
yes,
What
please.
question?
Just general question
Yeah, yeah, yeah.
about protecting processes. Let's say someone develops a process of research online. It's sort of a
Mhm.
methodology and would like to
Yeah,
protect
yeah,
it.
yes.
So how would you go about it?
The process itself is not going to make it copyrightable. Trademark, you cannot trademark that. You can only do copyrights. You can only do patents. These are the two options you have. You cannot put a trademark to a process. Okay. So
Patent.
let's talk about.
You
Hmm?
said you can also patent it.
Yeah, you can either patent it or you can copyright it. So what is patentable as a process will depend on so many factors, meaning that process itself will depend on whether it is mechanical, whether it is chemical, whether it is efficiency improvement, whether it is logistics of something, anything that is going to create or enhance efficiency of some process that has a uniqueness of, or it has an element of innovation to it, which means that it is not the process that is a combination of other processes, except their sequence is changed and that resulted in efficiencies, that's not going to be patentable. You can write something as a process and design it and make it copyrightable, but will be contested because anything that is copyrightable has to have an element of uniqueness or originality. So if the design is such that nobody else can make that exact design, that can be copyrighted. In order for you to have patents and for anything as a process to become copyrightable, you have to look at it from patents perspective and copyrights perspective separately. The requirements of copyrightable versus requirements of patentable have to be distinguished. And in both cases, the originality of process uh, will will have to directly or inversely be dependent on the innovation aspect or the knowledge aspect, which is not which cannot, which is not available anywhere in the world, or it does not have a parallel. It has to have a distinction. You can do more of the copyrightable process. It's easy to get it copyright, make it copyrightable, and it is very difficult to make it patentable. You can write something which is a process on a napkin on a piece of paper, and immediately it becomes copyrights. Okay, but somebody else can look at it and copy it, right? But when it is patentable, then you have to give a lot more details. You have to meet the criteria which the patent, and especially I would say that you should look at a chart which I emphasize is the most important chart in this chapter of trademarks or intellectual property. And this is the chart I'm talking about on page 456. Excuse me, I apologize. Here you could see that we have, let me just minimize it a little bit. See, in this chart, requirements of patents is described right here. Anything that is patentable and then compared with non-patentable. When you look at non-patentable, it is directing your attention to copyrightable product or anything that is can have a copyrights or can have a level of intellectual property, but not in the domain of patents. So this is where you're going to make the distinction. Elements that needs to be check marked or needs to be checked as part of the patentable goods has to be innovative, like it is describing here, and it is giving examples of what is patentable. The innovation is new, novelty. The element of novelty has to be there. The innovation is inventive. That means it is new concept. The innovation is useful. That means it has the practicality of use or for benefiting something, or it has a commercial value, or it has a value of improving anything, including the process. Then the innovation must not have a prior use, meaning that it is not something that is out there that is posing a threat or you have a competitor. And therefore I would think 35.1, which is a very useful chart, you can look at it and get a better answer for your question. Majdi?
Thank you. Yeah, I'm just looking at the screen. Yeah.
All right.
Yeah, it's very clear now. Yeah. Thanks.
So let's just conclude our session for today. And let's see whatever else we can finish up in the next lecture on Wednesday. Unless there is a need, I wouldn't go for the Friday lecture. I try to wrap it up as much as I can on Wednesday, day after. And I had mentioned earlier before, we started with this class. If you get a chance, um, see if you can open up your practice exams you know, the Q&As, the links that we were doing the other day, the previous class. Try to see if it is actually working. Don't have to do the tests, nothing that you have to spend a lot of time on. Just get to see if it is working for you or not. That's all.
Okay.
And good enough. So
Yes.
I'll see you next time.
All right. Thank you.
All right. Thanks again. See you next time.
See you. Okay.
Bye bye.